Hello and welcome to the LLG Grapevine podcast. You're listening to Helen McGrath, Head of Public Affairs, and Dennis Hall, LLG Bulletin Editor.
Hi everyone.
Straight in it this week, standards and ethics are always in the news. What's your take on the latest, Dennis?
Well, yes, Partygate will simply not go away. There's been one resignation and there are rumours of more fines to come, and possibly the chance to see some photos perhaps. Here's my story. Whatever your own politics, there's one thing I'm sure we can agree upon. Prime Minister Boris Johnson really does test the limits and boundaries of our legal constitution and the ethical considerations concerned with the rule of law. Standards and ethics are always in the news. The media is currently obsessed with the same question, namely, if you're a senior politician, you break the law and have been dishonest, then must you resign? Yet first, contrast the difference for a moment between politicians and lawyers. Politicians can sit back and ride things out in the court of public opinion. They send their flunkies out into the media to advocate their defence. Indeed, it seems any defence serves perfectly well. Not so for lawyers, however. Take the example of the case reported in the Law Gazette last week of a barrister whose disbarment appeal was recently rejected. Sky Beebe was disbarred last year following her conviction under the council tax reduction regulations. She then failed to disclose her conviction to her employer. In effect, her legal career is now over. So there we have it. Quite simply, if you practice law, then you break the law and have been dishonest, you lose your job, no question. The disciplinary body said that they had no alternative option open to them. But if you are a politician and a lawmaker, you break the law and have been dishonest, then you can keep your job. And Joshua Rosenberg points out another irony this week in his article concerning the resignation of law officer Lord Wolfson. It seems that while ministers who lie do tend to stay on, the government law officers usually resign when matters of principle occur. Indeed, there's now a long line emerging, including Lords Wolfson, Keane and Fawkes. There have been others along the way too. Yet curiously, fashions in political resignations were not always the same. Minister John Perfumo resigned immediately after lying to Parliament in the 1960s over the Christine Keeler affair, and then Lord Carrington resigned on principle over the Falklands War during the 1980s. But what is clear is this: the personal accountability of government ministers nowadays has all but vanished. Our legal constitution really does assume that ministers will do the right thing when they've been found wanting. By contrast, lawyers are held to account to different and far higher standards of conduct altogether. Now, my conclusion is this: it isn't our rules that guide our behaviours. Whether in politics or the law, it's your accountability to your own conscience that really matters. And on matters of ethics, rarely do you need rules to distinguish between right and wrong.
Now, changes to the eligibility to hold office are soon to take effect in the form of the Local Government Disqualification Bill, a private member's bill supported by the Department for Levelling Up Housing and Communities, which completed its passage through both houses on the 1st of April. Royal assent is expected within the week and commencement is due in late June. Updated guidance is hoped to be published at the same time as commencement. Once law, the Act will disqualify registered sex offenders who do not receive a custodial sentence long enough to trigger the current disqualification criteria. After commencement, individuals that are made subject to the notification requirements set out in the Sexual Offences Act 2003 or to sexual risk orders will be disqualified from holding elected office or standing for election as councillors, mayors, members of the London Assembly or Mayor of London. The measures, however, are not retrospective and will not therefore affect the May elections. Statutory consultation has begun with the Electoral Commission in respect of amending the election rules, with secondary legislation timetabled before the end of July. The private bill was tabled by Sir Paul Beresford, who has previously served on the Committee for Standards back in 2015, together with the Right Honourable Lord Udney Lister, who has been in the Lords less than 2 years. Now, returning to the theme of conduct and ethics, Junior lawyers, in conjunction with the SRA, have recently featured quite often in the news. What's happening here, Dennis?
Helen, indeed, yes. The SRA are recognising that junior lawyers need more support, and indeed a new approach from them is required. I explain the position here. In the old days, the disciplinary cases that regularly came before the Law Society and then the SRA invariably involved senior solicitors who had got involved in some form of financial wrongdoing. In addition to being struck off, solicitors faced both fines and costs involving eye-watering sums of money. Many could afford, nonetheless, to be assisted by the most expensive legal representation that was going around. These days, however, a new picture is emerging. Younger and unassisted junior lawyers are increasingly coming before the SRA, not because of financial impropriety, but more for hiding mistakes from their employers, far too fearful of being found out and losing their jobs. Often the working environment these days is so competitive that there is no one to turn to when honest mistakes occur. These lawyers have no support, no one to plead for their circumstances. But this may be about to change. Take the example reported in the Gazette last week of Claire Matthews. Claire was a former junior solicitor struck off after leaving confidential documents on a train. However, she has since been allowed to continue to practice after the Solicitors Regulation Authority agreed to drop the case. Claire Matthews had faced the prospect of a rehearing after the regulator agreed last year that her case should be remitted to the Solicitors Disciplinary Tribunal. Her case was subsequently supported by crowdfunding and pro bono assistance. Things then began to change. The regulator obtained its own medical evidence to assess whether Matthews had any issues with mental health at the time of the incident in question. The medical expert supported Matthews' contention that she suffered uncontrollable fear, anxiety, and panic following the loss of those client documents. Now let's hope that future cases will also be properly and fully evaluated like this one, and that the SRA will again intervene to get to the heart of the matter, as they finally did in this case. Doing justice does involve fairness.
Yes, it does. Now, also last week, legislation and guidance on the liberty protection safeguards and the latest information on progress towards their implementation under the Mental Capacity Act has been updated by the Department of Health and Social Care. It's worth reminding ourselves of these important changes because they have been delayed for some time now. The intention is that liberty protection standards will provide protection for people aged 16 and above who are or who need to be deprived of their liberty in order to enable their care or treatment and lack the mental capacity to consent to their arrangements in England and Wales, and will replace deprivation of liberty safeguards which have long been criticised and suffered immensely during COVID. The government has opened a public consultation on proposed changes to the Mental Capacity Act Code of Practice, which includes guidance on the new system. The consultation runs for 16 weeks from the 17th of March and closes early July. Some of the questions being examined include: how does the Act define a person's capacity to make decisions, and how should capacity be assessed? What does the Act mean when it talks about best interests? What protection does the Act offer for people providing care or treatment? What does the Act say about the lasting powers of attorney? What does the Act say about advanced decisions to refuse treatment? What means of protection exist for people who lack capacity to make a decision for themselves? LLG will be working with our National Lead for Adult Social Care and Health in forming a response to the consultation, and if you're interested in being involved in a roundtable to contribute, please do get in touch. Now, Dennis, you've picked out a case involving unlawful disclosing of personal data. What issues do these cases raise for local authorities?
Helen, unlawful disclosures of information can have dire consequences. But does the law always fit the circumstances of the crime? Here's the story. It was reported in the local government lawyer that an ex-employee of Hull City Council who disclosed a sex offender's address to a vigilante group has been fined £500. Chloe Carr, who was employed as a customer services assistant, came across the information in a council employee group chat and passed it on to an online group. According to a report from the Hull Daily Mail, around 30 people subsequently turned up at the victim's door. Prosecutors had initially sought to convict Carr of misconduct in a public office, but later chose to pursue the lesser sentence of unlawful disclosing of personal data, to which she pleaded guilty. At Hull Crown Court, His Honour Judge Burry told the defendant that he would have sent her to prison if he'd had the power to do so. Unlawful disclosing of personal data is only punishable by way of a fine. Carr was fined £500 to be paid at a rate of £50 per month. Now, this case raises many questions. First, was this case one where the punishment fits the crime? And was the prosecution that took place based upon the right offence? And of course, monitoring officers need to consider whether their counsels have the necessary safeguards in place to prevent this sort of thing happening in the first place. And I do think there is a link between this story and the first one I covered today about ministerial ethics. If in our democracy we see examples being set where our leaders regularly ignore the law and then seek to justify their own law breaking, then what message does this send to others in our society about the importance of complying with the rule of law?
In other news, Housing Secretary Michael Gove is reportedly considering plans to scrap the existing Section 106 agreement, which requires developers to build a certain number of affordable homes in favour of an infrastructure levy which councils could spend from. The Local Government Association says a shortage of council houses could lead to waiting lists, almost doubling to 2.1 million households in the next year, with 1 in 10 households in need of housing currently on a council housing waiting list. And former Prime Minister Theresa May has warned that the housing system is broken and letting down the next generation. Speaking at a conference on social housing hosted by the charity Shelter, Mrs May said that the problem can be traced back to a lack of action from governments of all colours, with the crisis beginning not because of a blip lasting a year or a parliament, but because not enough homes are built over many decades. Look out too for a letter to registered providers on social housing regulation draft clauses linked in the bulletin. And on that note, that's it for another edition of the podcast. You can read more on all the items discussed today and many more besides by going to bulletin number 15, available on the LLG website now. It's a bank holiday next week, so we'll be back for another edition on Monday the 9th of May. So until then, it's goodbye from me.
And from me too.
Thank you for listening,